There's no telling what is going to happen, but the bottom line is you broke the law. So if we are working with the same employer, it's not called additional work. So once you've been denied indefinite leave to remain, what is your fate? Does it mean that you're supposed to pack your bags and leave UK? What is up, guys? A month ago, I shared with you a video where I indicated that the government of UK is bringing about the change to the number of additional hours which one can take on a tier 2 visa or in a tier 4 visa. In that video, I had indicated that the government of UK had not officially updated the government website, so that information was not yet there in the government website, but people had received various emails from their employers and from their agencies. So with the effect from the 2nd of November, the government of UK put the official update on the government website, and when they put that update on the government website, it was dated back to the 4th of October, meaning from the 4th of October, you were only permitted to take 20 hours additional work. I know that in the comment section, there were a lot of people who indicated that they had not received an official update, so they are going to continue working until they receive an official update. So I don't know what is going to happen to those individuals when they are now applying for their indefinite leave to remain. It has been all over social media that a tier 2 visa holder was denied indefinite leave to remain because they took more than 20 additional hours. And this on its own caused panic amongst people. People are now confused what is termed 20 hours additional work. And I've received a lot of emails, people asking me to clarify. I'm working with my employer. Is it okay if I take more than 20 hours? Or if I'm working for the same employer, I'm restricted? And all those questions. So in this video, I'm going to clarify what additional work is, what is considered additional work. And I'll also say my thoughts about this individual who was denied indefinite leave to remain because they took additional work. So if you're new to my channel, thank you for stopping by. My name is Pauline Popomoyo, and in this channel, we keep things real. And for the returning subscribers, thank you so much, guys, for your love and support. It's greatly appreciated. Without wasting any of your time, let's get into it. I'm a savage. So for tier 4 visa holders, that is students, it is simple and straightforward. During the semester, you are allowed to take only 20 hours additional work, and on your semester break, you can take more than 20 hours per week. So when it comes to tier 2 visa holders, with regards to hours of work, there are no tier 2 restrictions for your main sponsored job, which means if you are working for an employer, let's say for example, you are contracted 36 hours per week. With that same employer, you can work for 72 hours, you can work for 5 days, you can work for 6 days, you can even work for 7 days, and that is not a problem because there is no restriction to the number of hours that you can work with the same employer. Even if you work 7 days a week, there is no problem. It's still fine because you are working for the same employer. But what you have to understand is if you want to work 5 days, 6 days, 7 days a week, the United Kingdom has got what we call a working time directive. A working time directive states that each individual is supposed to work for at least 48 hours a week. And if you're supposed to work for at least 48 hours per week, should you wish to work for more than 48 hours, if you want to work 5 days, 6 days, 7 days, you have to put it in black and white. You have to sign out of the 48 hours per week. The main reason for this, it has nothing to do with home office, but everything to do with employment rights. The employer, we don't have a situation whereby maybe someone says I'm overweight, they're making me work 5 days, they're making me 6 days, they're making me work 7 days. It's because it's illegal to make an individual work more than 4 days. So because it's illegal, you have to sign that document to say, in as much as this is illegal, this is what I want. My strength can take me up to 5 days, 6 days, 7 days a week. And we do work 5 days, 6 days, 7 days a week if we want. That is if we are working with the same employer. So if we are working with the same employer, it's not called additional work. What is additional work? Additional work is the work which you undertake with the second employer. If I'm employed by this organization, I can go and work for a second organization as an agency work. So this mostly confuses people who are working for the NHS, because when you're working for the NHS, if you do what they call bank in the NHS, you are only restricted to 20 hours a week. And then one might wonder, but it's for the NHS. Why am I restricted to only 20 hours a week? It's because the NHS also runs its own agency. So when it comes to the NHS, it's either the agency is run by a third party or the agency is run by the NHS itself. So if you are doing bank shift for the NHS, it's more like you are doing agency for the NHS. Hence, you are restricted to 20 hours per week because you have joined the NHS agency to work as a bank nurse. I hope this is clear because there's been a lot of confusion where people were asking, since I'm still working for the NHS, can I take additional hours and work 5, 6, 7 days a week? You cannot take additional work because you are working for the NHS agency, not for the NHS itself. So if you are working bank shifts, you are only restricted to 20 hours. In my opinion, the amount of money paid for bank shift in the NHS is far less than the money paid by other agencies out there, because this is the government agency and they pay you very little money. If it were me, I would opt for an agency which is not an NHS agency because it's going to pay me a substantial amount of money. I mean, we've got agencies here in Northern Ireland which pay you up to £40 an hour. So I would rather opt for an agency which is going to pay me at least £40 an hour rather than opt for an NHS agency which is going to pay me less. Well, that's just my opinion because I love money, and if you love money like me, smash that like button and don't forget to subscribe. Like I've already said, if you're not working for a second employer, there is no maximum or minimum number of hours that you can work. However, what you have to take note of is that even if you are to reduce your hours, at the end of the year, you still have to meet the salary threshold for a Tier 2 visa holder. For example, let's say if you're a healthcare assistant and the salary threshold is 20,400 per annum, even if you are to reduce your hours of work, you have to make sure that at the end of the year, those hours, they go up to 20,400 per year. Meaning, even if you are working as a nurse, if you are contracted 48 hours, should you wish to reduce those hours to 36 hours, of which I would advise you to reduce your 48 hours to 36 hours. Should you wish to reduce that 48-hour contract to a 36-hour or a 33-hour contract, it's still fine as long as the Home Office is notified and as long as at the end of the year you are going to meet the salary threshold for that sponsored visa. So guys, I hope this is very clear. The extra shifts that you take with your main employer is not additional work. So if you are working for your main employer, feel free to work 3 days, 4 days, 5 days, 6 days, 7 days a week, as long as you have signed in black and white that you are comfortable with working all those number of days per week because it's your strength. And as for the individual who has been said to have been denied an indefinite leave to remain because they worked for more than 20 hours a week, in my opinion, the individual did work for more than 20 hours a week. Did they work during the COVID times where people were permitted to work more than 20 hours per week? No, the individual did not work during the COVID times where they were permitted to work more than 20 hours a week. If the individual had worked more than 20 hours per given week during the COVID times, it wasn't going to be an issue because it was legal to do so, and it was clearly written in the government website in black and white that you can take up additional work even if it means taking more than 20 hours as long as it's in the shortage occupation list. So what is going to happen to this individual? This individual can take action within 14 days if they're in UK or 28 days if they're outside UK. If the individual is very certain that they did not work for more than 20 hours per given week, they can dispute that and they can be given their indefinite leave to remain. So once you've been denied indefinite leave to remain, what is your fate? Does it mean that you're supposed to pack your bags and leave UK? No, it doesn't mean that you're supposed to pack your bags and leave UK. You can still continue to work in UK under the skilled worker visa, which means you still need to be sponsored. You still need to have a sponsored visa. So can this individual still get indefinite leave to remain? Yes, they can still get indefinite leave to remain because I know an individual who got their indefinite leave to remain in UK after 20 years. After 20 good years because they'd committed an offense, and the offense was drinking and driving. And after drinking and driving, they were given a time frame to say in the next 5 years no drinking, no driving, no what. So when they applied again for indefinite leave to remain 5 years later, it was denied because they committed another offense, because they were also caught drinking and driving for the second time. So for this individual who has been denied an indefinite leave to remain, they're going to be given a time frame, can apply again after 5 years for indefinite leave to remain, and they will check that in the last 5 years, did you abide by the rules and regulations of the Tier 2 visa holder? So this individual, guys, is basically going to start afresh, can eventually get an indefinite leave to remain. But what happens is they're going to be given a number of years, because you are supposed to be working for 5 years, and in those 5 years, you're not supposed to breach any law. So you can be given an additional 5 years so that you've got a clean track record for the past 5 years, and then you apply for indefinite leave to remain. If you don't breach any law, you'll be given an indefinite leave to remain. This is not there officially on their website. This is what has happened to some individuals that I know, but their case was a case of drinking and driving. And then for the individuals who took up additional work between the 4th of October and the 2nd of November, when there was an official update on the government website, there is no telling what is going to happen. There is no telling what the government is going to do when you are now applying for indefinite leave to remain. And there's a likelihood that they can deny you indefinite leave to remain and say you took up additional work. So if you took up additional work between the 4th of October and the 2nd of November, you have to be truthful when you're now applying for indefinite leave to remain, because they're going to ask you a question whether it took more than 20 hours per given week when you're working for your second employer. And if you say no, when you know that on the 28th of October you worked more than 20 hours, you are lying. So you can say your truth and say you worked for more than 20 hours, because there was no official update on the government website, and the official update only came up whether it came up on the 2nd of November or whatever. I don't know whether ignorance is an excuse, but you have to be truthful when you're applying for a visa, because if you're not truthful and you lie, and then they come to you and say, but you can see that the week of 28th October I took 2 shifts, the week of 30th October I took 2 shifts. So when you're now applying for indefinite leave to remain, be mindful of this period. Make sure that you include it if you work more than 20 hours, that you work more than 20 hours, because there was no official update on the government website. And obviously, they might understand that. So I don't want to lie and say they'll give you I.L.R or they'll deny you I.L.R. But honesty is key. So do not lie and say you didn't when you did. So make sure that when you're applying for I.L.R, you say nothing but the truth. Because if you look at this person who are said to have been denied a indefinite leave to remain, they clearly state that you were asked if you worked more than 20 hours and you said no, but our records say you worked more than 20 hours. So guys, I'll talk and talk and talk forever, but if you've got any questions, drop them in the comment section. And if you found this video to be helpful, don't forget to give it a thumbs up and subscribe to my channel. Turn on the notification bell so that you never miss any of my videos. Thank you so much for watching, guys. I will see you in my next video. Bye.